Many of you will know that the rules for camping are very different in Scotland than they are in England and Wales. And the rules when it comes to land can be pretty complicated, although there are some maps that help to explain this and some other channels which I've mentioned before, such as Paul Messner's channel, which I will also link below. Paul Messner does a great explanation of how these maps help you to find various bits of land that you might be able to camp on, or at least be able to camp without too much difficulty. But if you're new to my channel, I'm a barrister who helps you to understand law. But for this video, since I'll talk about Scotland, I'll just emphasise that I'm a barrister of England and Wales, and whilst I can comment on Scotland, just worth bearing in mind that I am only qualified in England and Wales, and this video, in any event, cannot be taken as formal legal advice. But do hit that subscribe button and the bell icon, then you'll get notifications of new videos if you find this useful. As I said, the position in Scotland as against England and Wales is very different. In Scotland, for example, the right to roam laws make it possible to wild camp virtually anywhere in Scotland, except of course the obvious places where you cannot camp, such as someone else's garden or farmed land, or golf courses or other areas such as these where it's obviously not permitted to just go out and pitch up a tent. But otherwise in Scotland there are very straightforward guidelines that you should keep to and show a reasonable level of courtesy and respect both to other users of the land and in particular the landowner, because virtually all land is owned and controlled by somebody. Keeping your tent and your group small is always a good idea. Any fires that you might light should also be small and done with extreme caution, and being sensible that you eliminate the risk of serious damage caused by this fire. And obviously, as the saying goes, leave no trace, so you take everything with you so you leave nothing behind. In England and Wales, however, save for those areas that are dedicated for camping, such as camping sites and various areas of the country that are known to allow camping, for example, some parts of the Lake District or Dartmoor, but you always need to check precisely where you are as to whether you are allowed to camp in that specific location. But otherwise, the general position is that wild camping is not legal in England and Wales, at least not without permission of the landowner. Although there may well be some areas where the landowner will permit camping on the land, but it's always best to check that you have their permission first. The areas most likely to fall under this category will be areas of what we call open access land. Under Section 16 of the Countryside and Rights of Way Act of 2000, the owner of a piece of land can dedicate this area of land as open access land. The general meaning of this dedication of the land means members of the public have a right to enter the land and remain on it for the purposes of open air recreation. However, the basic position is that this right only extends to entering the land on foot, not, for example, by way of horseback or even cycling, although most landowners probably won't be too upset if you are cycling on the land. This is not the strict position as a starting point when land is designated as access land. And this basic starting point is what also restricts camping on access land, unless of course with the owner's permission. These restrictions can be found in Schedule 2 to the Act, but when an owner designates a piece of land under the Act, they are permitted to relax or remove any of these restrictions that are under Schedule 2. So this is a starting point, but doesn't necessarily continue with those initial restrictions. An important element to this is that once a dedication has been amended to remove or relax such restrictions, there cannot be a subsequent amendment to reimpose those restrictions at a later date, except in specific circumstances set out in paragraph 7 of Schedule 2, for example at the direction of a relevant local authority. For this reason, you may well find lots of pieces of land that are designated access land but have not had these restrictions officially relaxed or removed. But that's not necessarily to say that the owner doesn't want you to camp on that land. They may well have on their website some vague guidelines that they don't necessarily mind you camping on the land, provided that you treat it with respect, you take everything with you, and you don't cause a disturbance whilst you're there. There may also be parts of the land that they don't want you to camp on. For example, part of it might be used as farmland, part of it may be used for the landowner's own recreation, even though it is open access land, and therefore they wouldn't want you camping in that specific area. Many people have said that if you do go camping in fairly remote areas of open access land, that nobody really minds, but it is always worth bearing in mind that in the strictest sense, in England and Wales, you will need permission of the landowner, even if it is designated access land. And there are of course some areas that are going to cause you more problems than others. For example, public beaches are usually controlled by a local authority. Some of them come under a different regime, such as National Trust, which may be equally stringent. So if you are found camping on those areas, not only might you be asked to move, But you may also receive a fine as well under relative bylaws. And whilst most of these fines are going to be relatively minor, remember that non-payment of a fine can be a serious issue and you can be brought back to court if you refuse to pay such fines. It is also important to remember that if you take a dog onto such land, that it should be kept on a lead no longer than 2 meters long. And again, whilst most people are not going to complain if your dog is not on the lead and running around, this can be subject to scrutiny if your dog is jumping up people and they make a complaint, because strictly speaking, your dog should be on a lead no longer than 2 meters in length. But otherwise, and with all that in mind, open access land has a wide range of different areas that you can explore, strictly speaking on foot, but as I said, with all the precautions, you may well decide to wild camp there, but it is always best to seek the owner's permission. These areas include mountains, moors, heaths and downs, and even coastal areas of common land that are registered and controlled by local authorities. So if you are planning to go camping on such areas, particularly if you are planning on using a fire which may land you in further trouble, I would always urge that you seek the owner's permission just to clarify that it is okay to camp there. Let them know how many people are going, what the size of the tent is, how long you'll be staying there, and obviously just confirm that you are going to be courteous, take all of your rubbish with you, and then you may well find that the owner gives you permission, which will be a far safer position to be in than to be found and removed, and worse still, face any fines if there are bylaws in operation in that particular area. So I hope that provides a useful overview. Remember, I have other videos linked below and Paul Messner's channel, who does a great explanation as to how these maps work. And finally, thank you for watching, and remember, stay humble and subscribe.